We're rolling
Up there.
back on the record. We'll wait for.
Sorry, I didn't get my reading glasses.
No, that's fine.
Age.
And
Make my
Mr.
eyeballs go up.
Reid, I think we're still with you questioning this session.
Yes. May I draw our attention to a pleading filed on December 19th, entitled Respondent Hawaii State Teachers Association, Answer to Complainant David Reid's Third Amended Prohibited Practice Complaint. Oh, I can't read. So I inverted numbers. On September 13th, 2020, January, February, March, April, September, yeah. September 13th, 2023. Well, I copied. No, and I'm sorry. I reset. This is December 19th, 23.
You're gonna provide. Is the complainant gonna provide a copy to her?
If you're gonna refer, if you're gonna ask the witness questions of that document, then she should have a copy.
Okay.
Obviously.
So can I have it printed? Or can I speak to it? Can I ask a question about it without?
You could ask a question without showing it to her, but they can pretty much suspect that there's going to be an objection.
So may I have a very short, I thought I could present it digitally. Well, let me rephrase.
Oh, Mr. Reid, the problem is you have it digitally
Oh, so if I just give
as
her a
well
laptop,
as we have it,
okay.
but the witness doesn't.
So can I just let her read off my screen?
Have her provide him with his laptop.
Now, Mr. Alapa,
I'm fine.
Or
with
could
that.
I email it to?
Mr. Alapa said he's fine with you having her read it off of your screen.
Okay. Thank you.
And this is the document filed December 19th, 2023 at 12:27 p.m.
And yeah, it's good. And if they're gonna reference that statement that HSTA be awarded as attorney's fees and costs incurred to defend against this frivolous and meritless complaint, I can stipulate that that was a request made by HSTA as part of his answer, if that's what we're going.
Yeah, and a question or two past that. Do you need to see this anymore?
I
Well,
don't know. I don't know what you're gonna ask.
Yeah,
Well, okay.
if you're gonna ask any questions about that,
Okay.
but first, do you accept Mr. Alapa's offer to stipulate regarding the attorney's fees? Well,
Yes.
And with that stipulation, I'd like to offer a proof of how this relates to the issues presented and relevant for this hearing.
Mr. Reid,
Our complaint based on chapter 89-3 refers to our right to have concerted activities without interference from threats. And well, that one's to me. I interpreted that as a threat to bankrupt me because I can't afford whatever he's charging.
Mr. Alapa.
I can assure him that this is a standard practice, and it's allowed under the rules. It's not a threat to him. And we can look at complaints and answers, and it's pretty standard. And again, 89-3 in the context that employer complainants are using is for the purpose or the allegation that the union didn't stop and negotiate the repricing under 89F2. This is not related to that.
Mr. Reid, this is been doing this longer than I care to admit, but this is pretty standard language as far as this is a pleading in the case towards their answer. It's not included in all answers, but it is a pretty standard provision in there. And I'm understanding, and please correct me if I'm wrong, that your offer is that this was directed at you personally to cause you harm.
That it chill my actions with regards to my concerted activities.
But this was an answer to the complaint that you had already filed. So you'd already filed your prohibited practices complaint. And this was in response to that complaint. So how? Sorry, I just failed to see the connection with 89-3.
Well, the complaint is on at the time, and it still is ongoing, and it's not uncommon for people to get discouraged and to drop the complaint. I didn't.
Well, Mr. Reid, that's a decision that you make.
Yeah.
On your own, regardless of what position HSTA takes. So, if this is the issue that you're gonna get into based upon this pleading, that's as far as the board is concerned, that's not relevant to 89-3.
Okay.
Okay.
Grab mine.
Is that okay with you, Mr. Alaba?
Yes, thank you.
Mr. Takea, I assume the same. I don't mean to leave you out of the conversation.
No objection.
Yeah.
Switching gears. Did the HSC or did you provide did the HSTA to your knowledge, did the HSTA provide any documentation to the Department of Education about how many teachers could potentially be impacted by the 6 previous years of outside experience not being counted?
Did we provide documentation? I don't recall providing documentation to them, no.
Did you you previously said it was about 1,000 people, right?
Yeah, we're aware of that from various grievance actions that we've taken in the past and things like that.
And did you ever make that number known in any way to the Department of Education?
No, they know how many people potentially have had prior placement. The issue was they don't have the data readily available without pulling the files to know how much years and all of that.
I just wanted a little bit of clarification on a couple of things we spoke about earlier. Are you aware of when Senate Bill 1600, the budget bill, approximately when that was signed into law?
Is that the bill that provided the repricing money? Is
Yes.
that the one you're referring to?
Yes.
I don't think the governor signed it right away, so I want to say it was sometime late June, early
Okay.
July.
Do you? One sec. Do you recall when the Department of Education had the conversation with HSTA about the prior 6 years of outside experience, and that they would pull the funding or take it off the table? Do you know about when?
What do you mean pull the funding?
If I remember correctly, you had said that when that there was a discussion and the state said that, or to the effect, something to the effect of, if you push this, if you do this stuff, then we'll threaten to pull the funding off the.
That's not what I testified to.
Well, can you
I
clarify that?
testified that it was our belief that if we demanded impact bargaining or demanded bargaining, that they would withdraw their plan
Okay.
to do repricing. That is very different
Okay.
than a threat related to the 6
That's what I
years.
was- Okay, so is your belief? That's
Yes.
okay. Can you tell us what you base that belief on?
I think just my general knowledge and expertise as it relates to collective bargaining, the circumstances that were happening at that point in time, the fact that it was made very clear to us that the intention was that the funding would be for repricing via F2. That was communicated to us at some point. And so at the end of the day, F2 is employer discretion. So if we demanded some other avenue, they could easily just say, never mind, we're not going to do that. I think perhaps there's some belief for folks who are not intimately involved or understand the complexity of bargaining that you can just, demand things and that they have to follow. They are not compelled. They're absolutely not compelled. Even to the point that with earlier testimony that somehow there was a thought that if this labor board says the parties have to go back and bargain, there is no obligation by the employer to go back and do something different. The parties have to agree. There is no compelling on either side.
Are there any exceptions written, in reference to 89.9? Are there exceptions to the requirement to negotiate wages?
There are prohibited subjects of bargaining. That's what you're asking. I don't know if it's an 89.9. I think it is, but it might be in a different section of 89. There are prohibited subjects of bargaining. For example, we cannot bargain health plans, certain things around health plans. We cannot bargain technically classification.
I think you misunderstood my question.
Well,
Yeah,
you said
I would-
wages. Wages include classification, right? So under your definition that you've put forth, and the law prohibits negotiations around classification.
According to 89.9, are there any exceptions that were to the requirement to negotiate wages?
I'm gonna object, overly broad. I mean, there are so many ways this question can go on. I'm not sure what he's trying to get at.
Well, the wages defined under 89.9 are is the wages in collective bargaining is defined in 89.2. And there are three things that it defines wages to. That's the definition that I'm looking at.
Well, I'm gonna object to that. The Lax Foundation also misstates what the law is, and we went through this. There's a definition for collective bargaining, and in that context, it gave a non-exhaustive list of what wages can be. And one of those things was salary ranges, which doesn't apply to HSTA's contract. So the Lax Foundation misstates prior testimony and misstates the law.
That's fine.
Mr. Reid, if you could, with Mr. Alapa's objection, the other issue that I have is that 89.9 has 5A through F sections and then subsections to that. So it's like, what part of 89.9 are you referring to?
In reference to 89.9 F. Well, no.
You understand what I'm asking?
I think so, yes. We'll come back to it. So is it fair to say that the union does not consider?
No,
Oh,
first,
oh,
first, Mr. Reid, my question, because it has to do with Mr. Alapa's objection,
Oh,
is what section of 89.9?
can we come back to that question in a minute? Okay, I can ask a few other questions while she does some.
I'm just trying to find the statute 89.9.
Take your time
Okay.
and you can find it, because I have to make a ruling on Mr. Alapa's objection. We're not gonna move forward.
So. They have a copy.
Yes, I have 89
Yeah.
over here.
With regards to 89.9A.
And that's the section that your question concerns.
Yes.
Okay, go ahead and ask your question.
Are there any exceptions to negotiating wages included within 89.9A?
Could you explain to me what you're asking about exceptions?
Reasons that you wouldn't have to negotiate wages.
No, object to form of the question. It doesn't talk about on the 89A a mandatory requirement that the parties negotiate. It's a demand to negotiate and a procedure that follows. So it's not the way the 89A works, is not how he's framing it. So it misstates the law.
I'm gonna sustain that objection. You can ask another question, Mr. Reid.
Changing gears, to your knowledge, the DOE did verify approximately 9,000 plus years of service into their formula for repricing, correct?
9,000 years?
Oh, sorry, so 9,000 people's 9,000 bargaining members experience into the repricing formula.
Can you ask the first
Yeah,
part of the question? To my
Uh,
knowledge, who
to-
did this?
To the best of your knowledge, did the employer do the calculations to apply the compression fix to approximately 9,000 plus BU5 members?
And you're asking me this after or before? Like, I'm trying to understand.
No,
Just general?
in the implementation, like
Yeah,
they
Yes,
they
I have a full spreadsheet that has every person who was
Gotcha.
affected in the bargaining unit, including the three of you.
And you're also saying that it was their testimony that it would have been too much work to do 1,000 more.
Objection.
Or would have
That
been.
wasn't their
Sorry,
testimony.
would
My
have been.
testimony was that in part, the reason that one of the reasons that the employer provided was that they would have to pull the individual personnel files, just like they pulled for this case. I believe it's employer exhibit 46 to 48 or something like that. You have to look at multiple documents for every single person. We know that in the ballpark of 1,000 people had prior service. They would have to pull each of those individual files. They did not do that work to determine all of that when they provided the costing to the legislature. It was a 2-year funding, 121 million, 55 for each year. That's 110 million. The remainder was for 21 hours. Their position was there was not enough funding provided through repricing, nor was the data set that they gave the state or the legislature inclusive of those 6 years. And so their position was, we're not doing the 6 years. And so that is why when we did our proposal for the contract that followed this one, as we did the prior time, because we've been trying to fix compression for a while, that we did a comprehensive proposal around trying to address it.
No more questions.
I'm not done though, right?
No.
Okay,
Mr. Alapa. Cross-examination.
shucks.
Got
it.
Board member, I'm gonna request that we take a quick break for the restroom because it's gonna take a while, but I do want to first request that I be permitted to present our case in chief, in particular testimony of Ms. Eshelman, who we named as a witness because of time constraints, and she'll be off island tomorrow, not available to testify. And in doing so, I want to preserve my right to move or make motions after the complainant rests their case.
Yeah, I think as I mentioned yesterday, Mr. Alapa, that's acceptable, especially in light of Ms. Eshelman's schedule.
Are we gonna cross-examine and then do that, or just get straight to that?
I don't understand.
Well,
You just completed your examination of Ms. Eshelman. Right? Right, so now it's going to be Mr. Alapa's turn.
I think we'll do a cross-examination for all of it. Because right now, we've just been like, usually it's been us and then you guys and then us and then.
And Mr. Reid, you called Ms. Eshelman in your case in
Yeah.
chief, so you did your direct examination. Mr. Alapa is going to do his cross, but is also going to question Ms. Eshelman as part of his case in chief. And he's preserving his rights that he has because we're doing this to accommodate scheduling for Ms. Eshelman. Mr. Takei will have a chance to question after Mr. Alapa, and then we'll come back to you. Mr. Takei?
Hi, if Mr. Alapa is gonna proceed to his defense portion, is kind of what my understanding was. I was hoping to ask just a few questions regarding Mr. Reid's questions to Ms. Eshelman before
Before Mr. Alapa?
yes, just
Just to clarify, Mr. Takei,
yes.
you want to question Ms. Eshelman now before Mr. Alapa?
I'm sorry, I'm a little confused about.
Okay, let me explain the order again.
Okay.
Mr. Reid called Ms. Eshelman as a witness in his case in chief against HSTA. Because she is HSTA's representative and witness, Mr. Alapa would normally go next to question the witness. I will not preclude you, Mr. Takei, from asking questions, and then we would go back to Mr. Reid. So if you want to go prior to Mr. Alapa, I leave that between the two of you. If you reach an agreement, if not, as far as I'm concerned, it's Mr. Alapa's turn.
I don't have any problem when my turn is. I guess I was a little confused. We're changing a little bit the structure from what we did in the first half. So I don't mind if Mr. Alapa goes next, and I just ask a couple follow-up questions after.
I won't limit you to even a couple follow-up questions.
I apologize.
Because, and Mr. Alapa, correct me if I'm wrong, what Mr. Alapa is saying is that he's questioning Ms. Eshelman as Mr. Reid's witness in this part of the case, but also going to present his case, his affirmative case in his defense. So that he can only call Ms. Eshelman once based upon her schedule. So I think that's the only, and Mr. Alapa, you can correct me.
Yeah, and really the practical effect doing so is that I'm not going to be limited to the scope of the questions I asked by what he asked, and that's the only purpose.
Correct.
And
correct.
apologies about my schedule.
No, that's what we're trying to accommodate you.
Thank
Is it-
you.
You understand? Mr.
Yes, I completely
Okay.
leave it at the discretion of the board. I don't have any position, as long as at some point I can just ask a few questions.
You will go right after Mr. Alapa.
Thank you.
Promise.
Thank you.
Okay, you want to take a short recess?
If I could, I'll be real quick.
Okay,
Thank you.
let's take a 10-minute recess. Thank you.
I will go to just in case.
Recording. Thank you. Back on the record. This is the continued questioning of Ms. Eshelman, Mr. Alapa.
Thank you. Ms. Eshelman, what is your current position with the union?
I'm the Deputy Executive Director and Chief Negotiator.
And was this a position that you held during all relevant periods related to the complaints in this case?
Yes.
Can you please briefly describe your duties and responsibilities as HSTA's Deputy Executive Director?
As a Deputy Executive Director, I oversee field operations. So that includes our staff who do contract enforcement, training, and support for our members in the field. And then I also oversee legal matters related to the contract, and that overlaps with my chief negotiator responsibilities.
And could you also just briefly describe your duties and responsibilities as HSTA's Chief Negotiator?
So as chief negotiator, I'm the chief spokesperson for the organization specific to collective bargaining matters. I oversee and supervise a research and negotiation specialist. And I work with our bargaining team as well as our statewide negotiations committee on all things related to the contract collective bargaining.
How long have you been, how long have you been with the union, both as a member and staff member?
I became a member when I first started teaching in 1996. I transitioned to staff work in 2004. I was a field agent. And then in 2015, I became the chief negotiator for 6 months. And then I took a second job, if you will, and started serving as both the deputy and the chief negotiator in the summer of 2015.
Let me shift gears and talk about the salary compressions. And first, there's reference to Article 20, Section 6 of the 2021 to the 2023 collective bargaining agreement between HSTA and the DOE employer. In that section, talks about there be no step movements or annual increments during this period identified here. Can you describe what step movements are as the term is used in this portion of the CBA?
Yeah, so it's referencing that paragraph J, which is a provision that's been in the contract since 2001, that would allow for annual step adjustment or movement, a step movement on the schedule, subject to funding. And so that language, if you actually go back through our contracts all the way back to that period of time, has generally been in some form or shape to indicate that either we've bargained some very specific step movements during this time, or we haven't, and that's what that's referring to.
And CBA uses the term or references the term annual incremental step movements.
Correct.
And I know you kind of talked about that, but can you go into a little more depth on what that is?
So the premise in 2001, when that language was put into the contract, was that the parties had agreed that there is this idea that for each year of service, you would have this annual increment, you would move up in the schedule. And so that was called a step movement. Unfortunately, the state has not had funding for that. And so since that point in time, we have not had regular annual.
And related to that question, are step movements under the CBA automatic?
No, they must be negotiated.
Okay, and are they also subject to funding, as you testified to?
Yeah, so they're negotiated, and then there is this funding section, like I said, from Jay, and so that's prevented that language to be implemented since 2001.
Can you describe in detail what salary compressions are?
So the concept of salary compression is something that HSTA coined probably 15 years ago or so. We started looking at the issue and trying to find a way to describe the impact of having folks come into the salary schedule at the same or near step to people that have been in the schedule for a while, and the lack of movements then started to pile people up. I do know in one of the memos. I believe it was the October memo from 22, but it might also been in Kishimoto's memo. There's some charts that reflect that. So it's this idea that you could have somebody with 0 years of service and 10 years of service, and they might be on the same step. And steps are supposed to some way reflect experience. And that is the purpose of that, to recognize experience and time as a teacher. As research shows, the more experience you have as a teacher generally means you're more effective.
And can you give a brief description of the union's efforts to address salary compressions over the years?
So we've had it since 2001. We've done a variety of efforts to try and move in the direction of having an annual increment, unsuccessful because of funding impacts. We've tried to bargain it at the table. Some years we've been successful getting it every other year. Starting in 2013, after a couple of years of very difficult bargaining, we were able to successfully in that 4-year contract get it every other year, and then this next contract, same thing. We have also attempted to go to the legislature over time and try to bring back the annual increment legislation that was on the books in the 70s. That has not been successful. The legislature really has deferred to the employer and either the repricing or the collective bargaining process for that kind of compensation.
As a deputy executive director and chief negotiator for the union, I take it you've been involved with the discussions with the employer on fixes or resolutions to pass salary compressions as long as you were there.
Yes, so I have been, I was at the bargaining table with our team as early as around 2010, 2011. I was pulled in as a staff person to assist the chief negotiators at that time. And then since 2015, I've absolutely been at the table.
And I know you also touched upon this, but prior to the employer's compression fix, what have been the major obstacles to achieving a resolution to salary compressions?
I think twofold. One is just general budgetary constraints on the state of Hawaii. Our unit is quite large. A step is a 3% difference, which is fairly large when you compare it to other bargaining units. Some of them don't have steps at all, and the ones that do oftentimes are only 1%. So the cost of a step is in the tens of millions of dollars. I think the other thing is, in some cases, there's just a general political unwillingness to negotiate those things.
What changed between 2019 and 2022?
We, with the hiring of Superintendent Kishimoto, which came around also on the heels of them moving to, under the Abercrombie administration, they moved to change the law from an elected board of education to an appointed board of education. And so the premise was that the governor would have this authority to really push for changes in education. And so Kishimoto came on, Ige had a bunch of new board of education. There was definitely sort of this sense in the air that she recognized that we were not being competitive enough and that compression was a real challenge. She called for a salary study where they looked at comparable districts across the country. They did a whole bunch of data gathering, and she came to us and said, what are the things that you think we should look at? And addressing compression was a big part of that. And so there was definitely a political will to move in that direction. At the legislature, there was also a sense that legislators were willing to address the issue as well. Fits and stops of kind of like, where are we going to find the money, but definitely a willingness and a recognition that we needed to raise teacher salaries.
And all these factors lining up together, is that something that you did not experience in your efforts to address salary compressions in the past?
Oh, absolutely. It was so bad in 2011 that we had an opposed pay cut.
Can you turn to Union's exhibit RU-1, which is base stamp at U1 at the top right of the first page of the document? Let me know when you get there.
I'm there.
This document is already in evidence, but it's a memo from former Superintendent Kishimoto. Can you describe what's occurring briefly in this letter and what it communicated to the union?
The primary purpose of this letter, as it shows in the subject, was to have Kishimoto go to the Board of Education and request their approval to implement shortage differentials in various areas where teachers teach geographically in Hawaiian immersion programs and in special education.
And there's also attachments to this document, which begin on page stamp U11. Can you describe what these attachments were and how the union reviewed it and applied it?
Yeah, so U12 was an existing provision in our contract that provided that was providing hard to staff recruitment differentials. She wanted to expand the geographic areas, and so this was just to sort of speak to that piece. And 14 also explains that. And then I think 16 gets into sort of the geographic areas where there are positions, because there was a formula used for the shortage differentials. So this was all data related to impacts to shortage areas, and then there's some additional data embedded in the memo itself.
Can you turn to complainants exhibit U2, which is page stamp C9 at the top right?
9,
Yeah, C9.
Yep. I'm there.
Can you describe what this document was?
So at the end of the memo in December of 2019, Kishimoto added this little thing saying, I'm going to come back to you in January, and I'm going to come back to you with a plan to address this bigger concern I have, which is teacher compression, this compression on the salary schedule. And so this memo was her coming back to the board with her intention to implement an experimental modernization project. One of the things was, though, she didn't have money for this. In the case of the December, she actually got the authorization of the board to front 6 months cost for the shortage differentials, and then go to the department, the legislature, and ask for the money, because she felt that was important. For this one, it was more of a, hey, I want to do this. Can you get me some and give me authorization to go to the ledge and ask for money to help fund this?
And just for the record, this is a January 16, 2020 memo from former Superintendent Kishimoto, which is already in evidence. The memo references an experimental modernization project, or EMP. Can you describe what an EMP is generally?
So my understanding is that heads of departments within the state can utilize this as a mechanism to try and experimentally look at different ways to modify pay or compensation, and try to, attract and retain employees and things of that nature.
And it comes under a different statute other than Chapter 89, correct?
Yes.
And this HR 78-3.5 sound like the right statute?
Yeah, I haven't looked at it in a while, but I remember looking it up when we were
Right.
discussing this. Yeah.
Do you recall, and if you don't, it's fine, but do you recall if the statute HR 78-3.5 address negotiations with the exclusive representative?
I believe that the statute for this one has language that speaks to the fact that if there's a need to modify, then bargaining has to occur, modify the CBA, the contract.
Okay, so negotiations only occurred under the EMP if there are any modifications or waivers of any provision in a collective bargaining agreement. That was your recollection?
Yeah, that's my recollection.
And we can fast forward briefly, but when repricing was implemented by the employer, that was the same stance the union took. If there's any modifications or waivers of the CBA, you would be demanding negotiations, correct?
Yes. Yeah.
And was it your understanding, and was it represented by the employer, that the use of EMP was a discretionary function of the employer?
Yes. The employer was looking for a vehicle that was discretionary.
Did the union consult with the employer during the process that involved the EMP?
We did. In the fall of 2019, there were extensive discussions. Most of them focused on the shortage differentials that we referenced earlier. But we did have preliminary discussions with, this on their side. They were discussing what are the different sort of modes or options to move to address compression. And Kishimoto told us, this is the direction I want to go. whatever guidance she's getting from, Office of Collective Bargaining or whoever. And so we just, we were aware that she was going to present it. This memo came out, but we really didn't get into much implementation discussion beyond what's in this memo because we had to go to Ledge and get the funding.
In the January 16, 2020 memo, there's some data and tables included in there. Can you briefly describe this data set and tables and how it applied to what the union was doing?
Yeah, so if you look at C12, it talks about the percentage of teacher positions filled and the fact that we're not at 100%. So we always have a fairly high number of vacancies every year. While 93% may seem like a lot, that still means hundreds of positions that are left vacant or filled with day-to-day subs. The bottom of C12 speaks to the teacher retention rates, and they have it disaggregated by district complex area. And then C14 is some additional retention numbers over time, and you can see that we were kind of in that ballpark of the 55%, and superintendent was really looking to try and get to 60% within 2020, and then she had this goal of trying to make it much higher. And then I don't know if it's in this section. I know there's some more data elsewhere. I'm not sure if it's mentioned in a different area.
And so during this ongoing consultation process, the employer was provided the union with the results of its studies and other efforts it was making to review this process?
Yes, so prior to all of this, when Kishimoto first came in, she had an independent entity come in and do a salary study. So we were involved in that. We provided some of our feedback and data, and this contractor came in and did a bunch of research, like I said, on all different comparable school districts. And so we had all of that data. We had the data that we have collected over the years related to collective bargaining, and trends and things that we had.
Let me ask you about the nature of your role as chief negotiator. When you act as a chief negotiator for HSTA, do you work alone or do you work with a team?
I work with a team.
And for the relevant periods herein, were you the chief negotiator for negotiations and consultations with the employer related to salary compressions?
Yes.
And I take it that you had a team that worked with you.
Yes.
Can you describe your team, including identifying the members who are part of your team?
Yeah, so for like technical purposes, we have staff and then we have leaders. So officially under union policy, the bargaining team per se that I work with is comprised of the 3 state officers. So the president, secretary, treasurer, and vice president. And then it also includes the statewide negotiations committee chair, and then 3 additional members. Are you wanting me to share those names, or? And then there's a staff side that I can as well.
I think that's good for now. And were you the ultimate supervisor of this collective bargaining team?
Yes, so by our policy, we have, as chief negotiator, I'm the chief spokesperson, and I take the lead on all of that. They provide the decision-making and the guidance, and then I have to try and make it happen.
And, I think this is kind of a, important and rather large process. Do you delegate some efforts to your team? How does that work?
Yeah, absolutely. So, for example, if we're in bargaining and it's legislative session and there's things that have to be funded, our lobbying team, which in part is led by our state president, who is on the bargaining team, he is really taking the lead on some of the conversations at the legislature to make sure that the bills are moving along to get funding. I also have on the staff side, I have a negotiations research specialist, Colleen Bird, and she does a lot of the legwork, if you will, the research, checking in. She works very closely with our counterparts in the DOE, their negotiation specialists on their side. And then on occasion, our executive director also is involved in bargaining as well.
You heard testimony about bills that were submitted relating to the EMP. Did any of these bills pass as far as you know?
No, once legislative session shut down in March because of 2020 because of COVID, those bills eventually died.
I understand that in 2022, the employer changed its selected vehicle for addressing salary compressions from the EMP to repricing. Is that correct?
Correct.
Can you turn to Employers Exhibit R1, which is page stamp E8 at the top right of the first page of the document?
Yes.
Let me give everyone a second to get there. And this document is the October 6, 2022 memo from Superintendent Keith Hayashi, which has already been entered into evidence. And are you familiar with this document?
Very.
What does this document discuss?
So this is the culmination of years of work, and the final actual plan that was to be implemented. So this was Superintendent Hayashi's presentation to the board about what they plan to do to implement the repricing.
And whose idea was it to use repricing under HRS 89-9F2 to address salary compressions?
This is from the employer.
Did the employer consult with the union as part of his plan to initiate repricing under HRS 89-9F2?
Yes.
Who was involved in consultations related to the employer's pricing plan under HRS 89-9F2 on the employer side?
On the employer side. So we had individuals, we had essentially the superintendent, the assistant superintendent, Sean Bacon, Ainoa Naiole, which is the negotiation specialist on their side. And then they were also in discussions with DHERD. So at this point, this would have been Riker Wada in the fall of 2022, who was the chief negotiator and the head of DHERD. And then within his office of collective bargaining, Travis Palmara was the primary contact for the DOE issues for these types of things. Oh, and I'm sorry, one more, budget and finance as well, because we kept getting told that budget and finance had to review their repricing plan and give approval.
Can you describe the Office of Collective Bargaining, their relation to any type of collective bargaining that occurs would be involving DU5 members?
So within the structure of the state, DHERD, a subsection of DHERD or attached to DHERD is Office of Collective Bargaining. There's typically someone designated as chief negotiator. The last few years, actually for a number of years, that's also been two hats worn by the director for DHERD. They, at the table, represent the governor. The governor has 3 votes under law for anything related to contract. And so they really exercise a lot of influence in the bargaining process, even if they're not at the direct table all the time. Basically, DOE has to get permission from them before they do final sign off. Everything has to be, what do you call it, pushed up line, if you will, to get Office of Collective Bargaining. And by virtue, really, it is the governor giving his or her seal of approval.
And then you testified that OCB, representatives were involved in the consultation process in regard to the employer's repricing plan.
Yes, it was very, very clear. We were constantly having back and forth with the DOE where they would tell us, we got to go check with OCB, we're working on this, so on and so forth.
And can you also, for budget and finance, describe their role in collective bargaining activities involving BU5?
So budget and finance, they have to make sure that procedures are followed, that things are done the right way before they tell the governor they're good to go and the money can be released. And so they have to do all the costing as well. And so, for example, for this, the department had to, they got the allocation from the ledge, but they still had to put together a plan and give numbers up to budget and finance and say, this is our calculations. Does this match with what you're understanding we're planning to do, before budget and finance would give the final okay for them to move forward, and the commitment of the governor to release the funds.
You heard testimony about the requirement under 89-9F2 that the employer of each jurisdiction ensure establishment of procedures to periodically review repricing at least once every year. Do you recall hearing testimony about that? Yes.
Yes, sorry.
And part of that testimony was from Sean Bacon, who testified earlier in the hearing.
Yes.
Can you describe or strike that? And the statute doesn't say specifically a written policy or anything like that. It says establishment of procedures to periodically review repricing, correct?
Correct.
And you testified previously that the union did not have in its possession any type of written policy related to the employer's procedures to periodically review repricing. That was your testimony?
Yeah, we didn't have anything from DOE. Right.
Thanks. And through your negotiating team, was it represented to you by the employer that they had established procedures for the periodic review of repricing?
Yeah, I mean, I think they came to us and said, you know, we're gonna use this process. We have the data, we both acknowledge that there's this issue, and so we're gonna move forward with the process. And we did some initial kind of inquiry and kind of our own research. It was mostly my negotiation specialist doing that.
And were you surprised to hear the testimony from Sean Bacon that whether he didn't recall or didn't know or that it didn't exist, that he had no knowledge of a written procedure for the periodic review of repricing when he testified in this case?
Yeah, I think our understanding was that they had some procedures they had to follow, and that was inherent in those discussions of we've got to go back up to Office of Collective Bargaining, DHID, Budget and Finance to show that what we're doing is, you know, legit and okay within those expectations.
After you heard Sean Bacon's testimony in this case, did you go and discuss that representation that he made during the hearing with your team that participated in the negotiations, strike that, consultations related to repricing?
Yeah, I went back and checked with my research specialist.
And what was the results of you checking with your research specialist?
Yeah, she confirmed and went back and looked at her notes, was able to pull some documents that we found in our research around DHID's procedures, and verified that, you know, that the employer had told us that they were gonna have to do their own internal process, so that they were checking with OCB about what things they had to have in place to eventually implement. And, you know, this memo was sort of the culmination of all of that.
And you heard earlier in the hearing that the board took judicial notice of a DHID policy related to the periodic review of repricing. Is that the policy that your research specialist, Colleen Bird, identified to you?
Yes, sorry.
And so the union and negotiation team at that time relied on the representation by the employer that it had a procedure for the periodic review of the repricing of classes, and also received data related to that as part of the consultation process. Is that your testimony?
Yes.
And is it your testimony that the union had a good faith belief that the employer complied with HRS 89 89-9F2 based on the knowledge of written procedures, representations made by the employer, and the data that was provided to the union?
Yes.
Can you give us a brief description of what occurred during the consultations between the union and the employer group in relation to their new vehicle to use repricing as part of the compression fix?
So we had a series of meetings and discussions and looked at the data. They brought to us the chart, which is in this open memo, and said, you know, this is what we want to do. We want to do a reset, hold, look at everybody's you know, time in the unit and do this reset for one step for every 2 years. And we talked quite a bit about the chart, which is in this memo, that kind of shows everybody spread out over time, and the idea that we wanted to have a really tight reset of everybody so that they're moving up going forward. The other piece that was very important to us is that neither side wanted to touch provisions in the CBA that existed or salary schedules because we knew that we were preparing to go to start bargaining in earnest after we got this repricing addressed. And then the other piece was that we were absolutely adamant that they could not move someone down. So if you strictly applied their chart, there was a potential for some individuals to actually get a backward movement on the schedule. They might be, say, at step 9 or 10, and they could potentially be moved backwards. And we did not want that to happen. We were very adamant that no one should have see their salary rate go down.
You mentioned data provided by the employer about the spread of members on the salary schedule. You call that testimony you just gave?
Yes.
And is that in reference to the attachments to the October 6, 2022 memo from Superintendent Keith Hayashi?
Yes, yeah.
Can
yeah.
you reference page step 11, which is the first attachment to the letter?
Yeah.
And is this the chart that you're referencing?
Yes.
And can you give us describe what's occurring in this chart and what it's intended to show?
So this chart is actually based on data at that point in time, but we had been pulling data on doing similar charts for a number of years. And so if the chart, there's two sets of data. You can kind of see on the left-hand side, it says step. And then growing across the top, it says full years of service. And so the first set of data was where everyone was at the start of school year at the end of school year 21-22. So that was at the point in time they pulled the data to give to the ledge for calculation of the funding for repricing. That's where everybody was at on the schedule. And so you can kind of see, for example, there are brand new hires with 0 years of service. So they would have gotten hired sometime in the spring of 22, spring of 22 at step 5, there's 125. And then you can see that we have 41 people at the far end with more than 40 years of service. I don't know why they haven't retired, but they have more than 40 years of service. And then the chart underneath is the calculation if they were to implement, so the after effects, if you will, of the repricing. So to reset everybody, get them more tightly aligned to a concept of for every 2 years, you're at a step.
And was it the union's position, looking at these charts and the numbers and data provided here, that the proposed repricing plan provide more equity to the spread of membership on the salary schedule?
Yes.
Can you explain why the union took the position that it provided for more equity?
Well, as I've kind of testified before, there were chunks of time where there were no step movements. So what was happening is over time, people would come into the schedule and they'd be at the same step or very close to folks with, say, 5, 10, even 15 years difference in experience. And so that was very demoralizing to folks, and it made them feel like they were not being properly recognized. And so we wanted to kind of spread that out. The other reality is, if you were one of those people with like 35 or more years of service, you were definitely at the top of the schedule. But we had a whole chunk of folks who had way over 20 years of service, and they still were not at the top of the schedule. And so the idea was to just kind of reset everybody, get them back to a starting point. And the legislature was clear, like, we'll give you the money to do this, and then you guys got to go bargain going forward. And that's what we did.
And when you say bargaining going forward, you're talking about bargaining after the repricing plan was implemented.
Yep, and any sort of future step increases.
And if you can turn to the next page, which is page stamp 12 and E13, these are attachments to the employer's memo. Can you just describe what this is?
These are the salary schedules as they existed in the fall of 22. The exhibit B, which is E12, is the 10-month schedule. You can see that in the title. And then exhibit BB is the 12-month schedule. So we have 10-month teachers and we have teachers that work year round. So those are the 12-monthers. I don't know if you want me to explain anything else.
No, that's fine. The next exhibit, which is page stamp E14 at the top right. Can you describe what this document is?
14, you said?
Yeah, E14.
Yeah, so this is actually the start. So the first few documents were the memo and kind of the supporting evidence or data. And then this is the actual plan for them to implement the repricing.
And this is this document provided data, studies, and is something that the union reviewed, considered, and analyzed as part of the consultation.
Yes, so we had, we got, draft versions of this before they actually published to the Board of Education. And then we looked at the, we looked at the plan.
Did the union, through this consultation process, analyze whether the employer's repricing plan, or strike that, did the union analyze whether it should demand impact bargaining as part of the employer's, prior to the implementation of the employer's repricing plan?
We did, we talked about it, whether we wanted to do that.
And the union did this analysis and had these deliberations despite the employer's representation that it was utilizing 89-9F2.
Yes.
And can you describe the union's deliberations and analysis on this subject?
So specific to repricing, we knew we had this very unusual and unique opportunity. I tell people, I think it's once in a lifetime. I don't think I'll ever see it again in my time in union work, where the legislature recognized sort of outside of the normal bargaining process that there was this problem, and that they were willing to put forward the money for the repricing, and then ask the department to put together their plan and get the okay. And what we had was this opportunity to get funding, have an adjustment, and then go into working on the next contract, which is a 23-20, now 27 contract, and get additional salary increases for folks. We recognize that it wasn't completely perfect. The very reason that we're here, today, there was this dynamic that folks who had prior experience, the department was not going to use those numbers for any calculation. And we understood that that was a problem in the sense that, it wasn't going to fully recognize those things, but we were committed to, trying to address those in future bargain. But we did not think we would have this opportunity to get, a one-time infusion of over $50 million in adjustments for our members.
Did the union assess what the likely impact would be if it demanded bargaining prior to the implementation of the employer's repricing plan?
Yes.
And what was the results of that analysis and deliberations?
We were very confident that if we demanded to bargain the repricing, we tried to make a move to say, no, we only want to do this under F1 or no other way, that the department would withdraw their plan. And then that money would be lost. It would just go back to the state and it would get used for other things.
If that occurred, what would have been the impact to your members?
We would start, we would have a starting place for the next contract where we still would have this huge disparity in where people were at all over the schedule. We would still have compression, and we would have to make decisions about whether we prioritize that to the detriment of maybe across the board raises or additional step movements going forward, because we would have to commit to spending a large chunk of money to pay for that area that needed to be addressed, or we'd have to sacrifice it and continue to try and look for other options.
And more specifically, regarding the benefits that the 9,000 plus members who received proceeds from the compression fix, if the union had demanded bargaining and the offer was withdrawn, how would that have affected the 9,000 plus members? That
They would have gotten no change at that point in time.
And would they have lost the 55 million per year that they eventually did receive?
Yeah, the department was not authorized to use it for other purposes, so if the way the funding was written, it would go back to the state.
Did the union assess whether members who did not benefit directly from the employer's repricing plan would lose any benefits?
Yes.
And what was the results of that assessment?
So, like I said earlier, we put a big emphasis on nobody going down because there were people that were higher and we didn't want them to be lowered. We looked at the fact that we had, it's a chart. We had 413 people at the very top of the schedule. They wouldn't benefit from that because those folks were at 14B. We had a number of people that were in the first year or two of their service, close to 1,000 people that would not have necessarily benefited because they hadn't been long enough to have had compression. And then there were a number of folks that had been moving along in the most recent years who may not get an adjustment. And then the last group is a group that I think why we're here today, which is the folks who had prior experience. They were not going to get that added on to any DOE time that they had.
On that subject, you heard testimony from the complainants regarding their claim that their non-BU5 service was taken away as part of the compression fix.
Mhm.
You recall the testimony?
Yes.
Do you agree with that claim?
No.
Let's look at each complainant individually on this subject. You heard testimony from Ms. Campbell that she started at step 7. Do you recall that testimony? Yeah, yes.
Yes.
Yeah.
Yes. Sorry.
Can you go through, can you describe for the board the effect that the credit for non-BU5 service had on Ms. Campbell?
So I think the documents are in the employer's packet. But from kind of my memory and listening to the testimony, hers was a little bit more unique because she was in the unit before and then she came back in. So she left at step 2 at the point in time she left the unit. You actually started at step 1 normally. While she was gone, there was a restructuring of the salary schedule and you now come in at step 5. And so she benefited immediately when she returned from the lowest step she could be placed on was step 5. So she went from 2 to 5 upon her return. And then in addition, she was credited another 2 years to step 7 for the time that she served at the private school.
2 years or another?
Excuse me, another 2 steps, excuse me. For 6 years of service, equal to people that are in service.
And you heard her testimony that from step 7, she moved up 4 steps. Do you recall that?
Yes.
Can you describe those 4-step movements during that time period?
Yeah, I think she came in 2017, but there were 4 steps when I was looking at the documents. And so she would have moved for each of those negotiated steps. That's 2017, 2019, 20, no, she didn't. You came in earlier. She came in earlier.
2011.
Yeah.
I think.
I mean, if I can look at the documents, I can show them to you on the documents, but yeah.
And so she had 4-step movements from step 7. Now, can you describe what would have happened if she did not have a non-credit for her non-BU5 service, where she started at step 5? How would the steps have moved?
If she was not given that additional experience credit, she would have started at 5 and then she would have moved to 6, 7, 8, 9
Okay, so
during that time period.
so if the compression fix, strike that, if the credit for non-BU5 service time was actually taken away from her, what would have been the effect of her current step? Where would it have moved?
So she would have been moved back to potentially.
So from BU9 to BU7 or BU11 to BU9?
Yeah.
Okay, and was she moved backwards from BU11 to BU 9 as a result of the employer's compression fix?
No,
What about Mr. Reid? Do you recall, or do you know what his place,
so my recollection was his testimony and looking at the documents, in the file was that he came in at step, 7. And then since he's been employed, there was 1 step movement, so he was at 8. Normally, he would come in at 5.
and if he didn't have the credit for the non-BU service time, where would he have been?
So he would have been not at 8, he would be at 6 now, because he's only been here for 1 step movement at the time this happened.
So if his credit for non-BU 5 service time was actually taken away, he would have dropped the step.
Yeah, and then his is an added unique situation in that when you actually apply the compression fix, based on the time he's been in the unit, BU 5 time, he should only be at 7 based on the compression fix, the repricing. However, because we secured that agreement that no one would move backwards, he remained at step 8. So he's still actually benefiting from that added credit for his experience.
What about Miss Bess?
Hers was similar to Miss Campbell's. I believe though she had only had credited, I think she came in at step 6 and had 3 step movements, I believe.
You testified already that the employer made it clear to you that this was a vehicle and plan that was going to be implemented, correct?
Yes.
Did that stop the union from continuing its efforts to address compression fix issues for members such as the complainants?
No.
And can you describe what efforts the union continued?
So after we kind of wrapped up the implementation, and at the end of October, early November of 2022, people started seeing they got their personnel action forms, informing them of their adjustments, and then payroll started accordingly to those adjustments. And then we really started moving into bargaining in earnest. We had just had preliminary meetings and things like that with a new contract. And we passed across our formal comprehensive package in January of 2023. And in that package was both a proposal to specifically address people with prior experience, to do a reassessment, and then also a proposal in hopes of actually recognizing more experience. And so you heard Mr. Bacon, I think, testify to this about we had asked for up to 22 years of service. So we were proposing both of those things at the table.
Yeah, so during these relevant periods, the union was negotiating on behalf of these members relating to the compressions, salary compressions.
Yes.
Why didn't the union force the employer to agree to cover these employees or these complainants?
We can't compel them.
And why is that?
The law doesn't allow it. We can't compel them. We have to, it's a process, it's a negotiations. It's, the law is set up to try and bring the parties together and to reach agreement.
Your testimony during this hearing about that uses the terms step movements and adjustments or repricing. Can you describe what those terms mean in relation to the employer's compression fix?
So related to the repricing, it's been characterized, or it is characterized as an adjustment, a salary adjustment. In this case, we're adjusting their salary to a different step.
And is that a different term, the adjustments, than the term that's used in the collective bargaining agreement under Article 20, which is step movements?
Yeah, step movements or annual increments. So those are negotiated.
Yeah, and I know this touches upon what you already talked about, but can you just describe the difference between the terms salary or step movements as used in a CBA and the salary adjustments that occurred with the repricing?
So the salary adjustments were a reprice. We're going to look at these folks, we're going to assess their time in the service, and we've determined that we want to make this reprice for them. We're going to adjust them to a different step. The annual increments, right, or those step movements are those that we negotiate, or if there is funding, there is that provision in the contract that they can get that annual increment subject to funding. And then that's just you move one, or you move whatever we we agree it's normally just one step a year.
And were there any step movements, as the term is used by Article 20 of the CBA, in the implementation of the employer's repricing plan?
No, it was an adjustment for certain people who met certain criteria.
Let me just ask you generally about the term collective bargaining. Does collective bargaining include negotiations and consultations?
Yes,
And that's found under HRS 89-9.
yes.
And the duty to bargain and consult is part of the collective bargaining process.
Yes.
You have the CBA in front of you?
Yes.
Can you turn to Article 20, which is page 68 of the collective bargaining agreement from 2021 to 2023?
Yes, I'm there.
A lot of discussion has been had about Section E, where it begins new teacher hires or new hire teachers.
Yes.
In your expert opinion on the CBA and collective bargaining laws, can you explain what the meaning and effect this provision has?
So this provision started showing up in our contract in the early 2000s after the teacher strike. And it was in part to try and slow down some of the compression issues. Oh, I'm sorry, this is a different section. I thought you were asking me about the another section. Sorry, this is related to prior service or prior, experience. And so if they have the prior experience outside of bargaining unit 5, so that could be private schools in the state, that could be foreign, like they work at DoD schools or they work somewhere internationally, and it can be places on the continent, in the United States. And so the department, when you apply, you can tell them you have prior experience. They will ask you to fill out some paperwork, get some documentation, and there's examples of that in the exhibits. And then once that is submitted, they will do an assessment. You're required to have worked in an accredited K-12 school, and then they will do an assessment based on that chart that I had talked about earlier to give that 6 years. And it's an initial placement when you're entering. They don't do another assessment at a later date. It's just, you have a one-shot deal. So if you come to them 3 years later and go, oh, I didn't know there was this opportunity, they're going to tell you too bad, you had to process it at that time. It works in conjunction with the salary charts that are in the contract. And you'll see on the salary charts, there's an initial placement, and then there's a reclassification coding on the charts.
You heard testimony and discussions about the terms, the initial placement and versus a continuing obligation. How do those terms apply to this provision?
This is all about when you first come in, where you get placed. That is your starting place on the schedule. And from that point forward, any adjustments are generally bargained, or in the case of the repricing, there were some people that got moved as well.
And in the first sentence, it refers to new hire teachers entering the salary schedule in 2021 to 2023. What does that mean?
So, like I said, the language similar to this has been in multiple contracts, and so we just update it with the years each year. Is that what you're asking about, the years?
Yeah.
Yeah. So we just update it with each new contract. If you look at the new one, it'll say 23, 20.
Based on the language here, would this provision apply to teachers that did not enter the salary schedule in 2021 to 2023?
No, it only applies to people who are brand new hires at that time. It doesn't even technically apply to people who are coming back into service and re-entering service like this.
If you can turn to section C of Article 20, just above that, turn your attention.
Oh, okay.
There's been discussion on an alleged violation of this provision. In your expert opinion on the CBA and the collective bargaining laws, did the employer's repricing plan violate section C?
No,
In your expert opinion on collective bargaining laws in the CBA, did the HSTA violate any provision of HRS chapter 89?
no,
In your expert opinion in the collective bargaining laws, did the union act willfully in violation of HRS chapter 89-13?
no.
That's all I have. Thank you.
Thank you, Mr. Alapa. Mr. Takei?
Thank you. Can you turn to 89(9)(f)(2) again, please?
Mhm.
Okay. And we've been talking about this provision dealing with the establishment of procedures, correct?
Mhm.
And would you agree that the procedures are to ensure that the employer periodically reviews at least once in 5 years, unless agreed to by the parties, the repricing of classes within the bargaining unit?
That's what the language says.
Okay, so you would agree that that's the purpose of the procedures, right? What you just said.
Well, the language says that the employer is required to establish procedures.
Yeah, and then the purpose of the procedures is what I just said, right? To ensure that the employer periodically reviews at least once in 5 years, unless otherwise agreed to by the
I think
parties.
you could say that. Mhm.
Okay. And I'm sorry, preliminary, in your position as the chief negotiator, you're familiar with this provision and
I'm generally familiar with chapter 89, yes.
okay. Now, back to the procedures. By looking at that statute, does it set out any standards that's required for the procedures?
No, that generally would happen in like the at the departmental level.
Okay, so would you agree that the employer has absolute discretion on what those procedures
Yep.
are?
They would have to decide how they would do that periodic review.
Do they need HSTA's approval of whatever procedure it is that they come up with?
No, typically there will be consultation if the procedures are going to impact collective bargaining, but
Um,
I mean, if they're just doing
just
review, I don't think they would need our permission, no.
okay, so just looking at the language of the statute, in your professional opinion, from your
Right.
experience as a,
I think the only thing that would require is if they decided that they were going to either do it more frequently or less frequently, because a statute does indicate that if it's agreed to by the parties, you could do it outside of that 5-year
okay,
timeframe.
but if it does meet at least, or it meets the requirement of at least 1 year, what the procedures would be at the absolute discretion of the employer.
Yeah.
Would you agree with that?
Yeah, they got to figure that out. That's not my kuleana. I'm sorry, not my responsibility. Although Hawaiian is a official language of the state.
So even if the employer decided to change its procedure from 1 year to the next, they could do that too, right?
Of how they do their periodic review? I suppose so, yes.
They can change their procedure as long as it ensures that periodic review.
Yep.
As long as it ensures the purpose that I read earlier.
Correct.
Okay. It doesn't need to be the same procedure every year?
I don't, that's up to the employer.
And each um em- employer of each jurisdiction can have a different procedure. Would you agree?
I don't think the statute really speaks to that, but I believe that is the practice of the state. I don't think it prohibits it.
Different departments can have different procedures.
Yeah, and
would you
I would venture to guess, although I only work with one bargaining unit, that even within different bargaining units, they may have different procedures depending on the complexity of their salary rates and things like that.
So, and this procedure isn't required to be published to the public by your reading, does it?
The statute doesn't appear to require that.
Okay, so would it be fair to say that these procedures are internal procedures to the employer?
It would, I mean, I think if that's the position the employer wants to take, then they're allowed to do that.
Okay.
It probably would be subject to a FOIA request, but other than that, no.
Now, Mr. Bacon testified earlier that it was the department's procedure to periodically review repricing at the time that each at the time of renegotiation of the CBA agreements.
Yes, I recall him saying
Did you
that.
recall? Okay.
Yes.
And he said that during those times, it was the procedure to review the employees' salaries, view 5-member salaries, see what the issues are. And I am paraphrasing, but see what the
Yes,
issues are
I recall him saying that.
and see if they can find any maybe creative ways to deal with money salary issues. Do you agree with my paraphrasing of what
I think that I don't remember word for word, but yes, generally he did testify to the concept that they review during the collective bargaining process.
Okay. And do you have any reason to doubt that that is the DOE's procedure for periodically reviewing people's pay?
For repricing purposes?
Or
Any doubt?
or that do you have any reason to question Mr. Bacon's testimony that that was the department's procedure in, I'm sorry, trying to get the language, to periodically review the repricing of classes?
Well, I mean, that's what he testified to, so, and that's, you know, what they articulated to us, right? We do this, we have our procedures, we're gonna ensure that they're followed so that Office of Collective Bargaining, DHERD, Budget and Finance are all satisfied, because we can't implement this without getting those okays. So we trusted that that was their responsibility.
It's the
Because
employers.
for us, our thing was recognize there's compression, recognize there's a problem, and the employer was doing that. And so their responsibility on their side to ensure that they're addressing those things, that's their responsibility.
And then you said you defined repricing earlier as, I'm sorry, and correct me if I'm wrong, you know, along the lines of like changing the pay of EU5 members.
It was an
is there-
adjustment, yeah, so they had an adjustment.
Okay. Can you define repricing for me again, the way you said it earlier? If you remember,
I mean, in the case of our unit, there was an assessment of the unit, and based on certain criteria, in this case, it was trying to reset the years of service to be more equitable. And they made a one-time salary adjustment for those folks and moved them to a different step.
Okay. Okay. How do I phrase this question? Sorry. Assuming repricing means changing the price or changing the salary of bargaining unit 5 members. If you make that assumption.
It's gonna,
Oh,
sorry, I'm gonna
Okay.
object to the use change. She said adjusted.
oh, I'm sorry. Adjusting.
Are you asking about an individual employee, or are you talking about?
Oh,
the
just the
whole unit?
definition of.
Because we did
repricing.
not change the salary schedule, so the actual salary schedule, depending on what box you're in, did not change.
Okay. Actually, that's not where I'm trying to go. Okay, but. Is adjustment of pay
Hmm.
a topic that comes up at almost all the CBA negotiations that you've been a part of?
So we typically negotiate changes to the salary structure. So we'll negotiate saying across the board, so every box gets a percentage increase, or we will negotiate a step movement, right? Or an annual increment, those types of things. So, you know, wages can mean a lot of different things. We have negotiated bonuses and supplemental pay. So anything having to do with money.
Okay. So let me rephrase. Is wages a topic that comes up,
Money is always
is always a issue?
the number one thing that we get repeatedly over surveys, and I think that's human nature, is you would like to get paid top dollar for your work.
Okay.
So yeah, money is always an issue.
And from your experience, and I believe you said from 2015, you're the chief negotiator, and
Yeah.
then,
Mhm.
And then you've been a part of some, negotiations
prior to that.
that.
Mhm.
So in those experiences, did wages and methods, of all sorts, but concerning wages, trying to achieve the goal of increasing wages,
Mhm.
come up at each of your experiences?
I would say it probably comes up at every bargaining going back 50 years. I don't
Okay.
think that's unusual.
Okay, thank you. Now, can you turn to this is board exhibit, how am I gonna do this? This is the you have it,
I have it.
2021 CBA.
Yeah, if
What's the
I can
letter?
ask,
C?
excuse me one second. I know we have to finish Miss Eshelman today, but can we just take a short 5-minute recess and then push through until she's done?
Sure. I only have a few more questions.
Okay, we'll stand in recess.
Okay.
Back on the record, Mr. Takei, can continue.
Thank you. One more question before the CBA. You mentioned that compression fix was a issue that's been discussed with the DOE for decades. Is that right?
So yeah, some of it started in the early 2000s. We actually, some of the old timers in the room may remember this. We actually negotiated a fix in 2012, and then our unit voted it down with Governor Abercrombie. So yeah, it's been a long time.
And as much as you know, has repricing been discussed as a vehicle before?
No, not with our unit.
Not with
Not
your-
to my knowledge, since 2015, no.
Okay. But different ways of trying to see how to address the issue has been discussed.
Yes.
For decades.
Yeah, so the compression started really in the early to mid 2000s. So like 2008 was really the start of the real problem where we had a number of years with no step movements.
Okay, and okay, so now could we go to, this is the CBA, Article 3, the negotiating rules.
Hmm?
We can look to letter D.
What page are you on?
Of page 2.
Two?
Yeah. Or at least on mine, it's page 2. I'm not too sure,
Hold on.
but it's Article 3.
I know it's
negotiating
up.
rules.
Oh, there it is. Yep.
And
Yep.
Mr. Takei, I'm gonna let you pursue this, but I'm just gonna caution you that this was, to my recollection, not something that was really discussed in the examination, but I'll let you go. I'm gonna give you leeway to
Okay.
get into this.
Thank you. So it says, when an agenda for negotiation is completed and accepted by both parties, no additions may be included unless approved by both parties. I read that right?
Yes, that's one of our rules.
So would you agree it's one of the requirements to establish an agenda for negotiations?
If we're doing negotiations, yes.
Okay. And can you describe how an agenda for negotiation is typically put together?
If we're talking about bargaining the contract, it frankly varies. It varies depending on who the folks are that are working on that agenda. I have experienced bargaining with the state where we call each other on the phone the day before. It's okay, we got a session scheduled tomorrow. What are the 4 topics we're going to talk about? And I've experienced the flip side with the current superintendent in the last bargain. He was very much wanting to have a very defined agenda with date, time, and start time, end time, and detailed, information about what topics we would discuss.
Okay,
So it can vary greatly. It's just basically the parties got to agree with what they're going to talk about. It's not it's not very profound. This is just kind of not common negotiations rules.
okay, so am I understanding accurate that you establish an agenda sometimes verbally, sometimes more formally?
Sometimes in writing, yeah.
It just depends on who the parties are.
Yep.
Okay,
Yeah, sometimes we've done it on chart paper at the
Okay.
end of the prior session. Okay, what are we gonna talk about next time? Chart it up.
okay.
These
If
are
it-
these are teachers. They're very flexible.
If indeed it said that it needed to be written, then you would take the more formal approach, is that correct? Well, is that?
Yeah, I mean, well, so maybe I can clarify. So if we call each other or we have a conversation and it's gonna be topic 1, 2, and 3 tomorrow. What will happen is when people show up, my negotiation specialist will have an agenda printed for everybody. These are the 4 topics we agreed to. It's not rocket science.
Okay. And now, until the agenda is put together, is there like pre-negotiation discussions that go on
Sometimes,
to agree on what is put onto the agenda?
sometimes.
Mrs. Takei, what is your offer of proof on negotiations and an agenda? Because I think it's pretty well settled that there was no negotiation.
Well, my offer proof is Mr. Reid. I know it was a while back, but he seemed to make the allegation that repricing was never put on the agenda. And I just wanted to ask questions to see what types of discussions may have occurred that could have been left out of what earlier,
Why don't you simply ask her if repricing was put on the agenda?
no, she already answered that.
Okay, and
She
I
said
guess,
she
I
did.
guess that's my point. I'm struggling with what the relevance is of this line of questioning.
Mr. Bacon testified that the procedure was to discuss wages and such during the collective bargaining process, as part of the process. That is DOE's procedure. And Mr. Reid, through his question that he asked, was repricing put on the agenda based on Ms. Eshelman's knowledge, and I think she said she doesn't remember repricing being put on the agenda. I was trying to ask if there were discussions about wages and methods, perhaps repricing, that may or may not have occurred as part of the collective process, but may not necessarily have been put on the agenda that Mr. Reid was asking questions about earlier.
All right, Mr. Takei, the short leash. This is
Thank you, sir. Well, were were negotiations from your memory? I'm sorry, not negotiation. You said earlier, wages and methods to try to get higher wages are almost always talked about at negotiations.
If we're talking about negotiations for successor agreements, wages are always on the table.
And then
And maybe just to help you, the word repricing, as I testified earlier when David asked, has never been, in my experience, on a negotiations agenda.
what about pre-agenda?
No.
Okay,
Repricing has never been discussed in the context of negotiations, my experience.
And by
Repricing has only been discussed in the context of F2 for this one-time salary adjustment that occurred in October 2022.
okay.
That was this limited period of time for that one-time event.
So has repricing never been done through negotiation, HSTA?
No, I testified to that earlier. We've never had, in my experience, I'm not aware of any repricing through F1.
Through F1. Oh, okay.
Because that's the repricing option that you bargain. F2 is employer implemented.
Okay. Okay, I'm sorry, that's the only questions I have. Thank you.
Okay, thank you, Mr. Takei. Mr. Reid, do you have any read there?
Just very, very briefly, you testified quite a bit about your opinion on the policies of the Department of Education with regards to the procedures for repricing, correct?
About my experience or knowledge,
Yeah.
yes, I testified to that, yeah.
Do you have any work experience, right? Do you have any work experience as a manager in the OTM? Office of Talent Management?
I have only worked as a teacher for the Department of Education.
That's all.
Based upon that, Mr. Alapa, you have any further questions?
No, thank you.
Mr. Takei,
No questions, thank you.
Board Member Moifono, do you have questions?
Yeah, just one. Ms. Eshelman, you stated that there was a one-time adjustment to certain people's salary. Is that correct?
Yeah. That was what the repricing was, yes.
And that adjustment became permanent, right?
Yes. When
Okay.
you read the memo, it speaks to that in the implementation plan.
Right, and it's now become part of DOE's base budget, correct?
Yes, that is my understanding, that it is now their base and that's what they'll, when they do their proposal for their salary costs.
And so if you folks negotiate another step up, then the step up would be based on where they are today. Is that correct?
Yes, ma'am. And in fact, in the new contract, there was a step that just occurred. And so it was anyone, if they moved, say, from 10 to 12 in 2022, in August, they would have moved to 13.
Okay, great. Thank you. That's
You're
all I
welcome.
have.
Okay,
Board Chair O'Shea.
okay, yeah, thank you. Just a couple of questions here. So I'm just kind of squaring Mr. Bacon's testimony. So I believe he testified to the effect that in his experience as a deputy superintendent, that this was the first time that the DOE had used HRS 899 F2 with the HSTA. Would you agree with that?
To my knowledge, that's accurate, yes. I'm not aware of any other F2. Now, there may have been stuff back in the day, but not to my knowledge.
Would that also apply to you and your role as at the HSTA?
I'm sorry, Chair, could you clarify?
Yeah, I think Mr. Bacon said that when he was, as his role in this, as a deputy superintendent,
Huh?
he couldn't recall anytime the DOE using 89-9 F2 with the HSTA.
I'd be comfortable testifying back to 1996 when I started teaching. I'm unaware of any repricing that has occurred since then to now.
Any repricing using 89-9 F2.
Correct. For bargaining unit 5.
Okay, so it's safe to say that this was the first time in your experience that it was used for repricing purposes.
For bargaining unit 5.
Yeah.
Yeah, and I'm fairly confident it is. I had a very close relationship with Joan, who said she was my mentor, and I don't ever recall Joan speaking to repricing occurring for the unit. I know there were some adjustments that happened over the years, like in the early 90s, but I'm not aware. What is, like, you guys are having computer?
Okay. Telling me keep it moving. Okay. So, so the legislature is in session and you folks started off with thinking about using an EMP process, then it goes into, no, we're going to go with repricing instead, or through Chapter 89. The legislature does its business and the governor signs or approves the funding in Act 248 with a proviso.
Yes.
Is that when you folks started the consultation process?
Yeah, as soon as, we were aware that things were moving through, we were aware that the bill passed out. And there were periodic conversations that I would reach out to Sean, or OSA might reach out to Keith or what have you, the superintendent, and ask, hey, where are we at on this? Do you want to preliminary start those discussions? And Sean's answer to me was always, no, we want to wait to see if the governor signs it. And so then once the governor signed it, which I think was like early July, it might have been end of June, I'm not exactly sure. Then I looped back around. I said, okay, the governor signed it. First thing on our list was to deal with the 21 hours. So we have a provision in our contract we've had to renegotiate every couple years. It's called 21 hours of job embedded professional development. It had been paused during COVID, during the first year of this Brown contract. And so we quickly negotiated reinstatement of that. And then we got down to, in late July, early August, really talking about what are they looking to do for the repricing.
Okay. So at that time, was there a decision that the board had made or DOE had made regarding excluding the credited service of the non-BU5 teachers?
Yeah, to my recollection, sometime at the end of July or early August is when we first learned of this. I know this because we had a statewide leadership meeting admissions day weekend. And I remember speaking to, like, this is the preliminary discussions and giving our statewide leaders an update. That was actually like filmed and I think pushed out to some people or whatever, but I clearly remember sharing that and having some discussion about the department's position at that point in time, and that we were gonna try to address it, but they seemed very firm that they were not going to recognize that prior experience.
So I think when I'm looking at that memo, it talks about the adjustments of 55 million and some additional monies.
Mhm.
But that's for the two years of salary adjustments for the eligible teachers, excluding the non-BU 5 experience.
My understanding is it was 55 for each year. And then you double that for the biennium, and the 121 was supposed to be the biennium cost.
So that kind of matches up with the appropriation amount in the legislature.
Yeah, because then you also have to add the 21 hours, which I want to say are like 15 million a year, something around there.
So, you followed, I mean, let me ask you this question. You're aware of the budget itself, appropriation, also the proviso attached to that appropriation, right?
Yes, that was one of the things I was following closely as it came out, because I wanted to know exactly what that proviso said.
And so the proviso seemed to express the legislative intention that the money will be used for a period of time, and it would be for repricing.
And collective bargaining, yes. And I went back and asked my ledge folks, my staff at HSTA about that. And what the message that came back to me was, originally there was going to be a separate item for 21 hours, and for whatever the sausage making that came out of the ledge, they put it together. And so we were told, oh, that extra is for the 21 hours. And so I can't point to a proviso that tells you that, Chair, but that was our understanding.
So it seems to square with the appropriation amount for those 2 years.
It was actually a little bit short, but I guess the department just came up with the money from other things.
Okay, and I think also, I'm almost done. I think this is on the memo, October 6, 2022, to the chairperson from Mr. Hayashi. I think there's some language that I think that this increase is going to be fixed into the base budget of the DOE EDN 100 going forward, right?
Yes, what I was told from my counterparts in the DOE, there was a lot of discussion about that and making sure that there was documentation, because the Department of Education did not want BNF to turn around and suddenly say, oh, you're short, we're not going to give you that 55 million. So there was a lot of discussion at the executive level. I obviously wasn't necessarily directly a part of that, but that was what I was told by the DOE though.
And that's your understanding today, right?
Yes, my understanding is it's included in the base, and as the budget is now moving through this session, it should all be there.
And there also was an understanding, or maybe it was an agreement with the board, with the DOE, that any changes were being made to the salaries that would be pursuant to the contract. Is that correct?
I'm not sure. Any changes would be pursuant to the contract. Could you?
Any
Clarify.
salary adjustments would be negotiated?
Going forward?
Yeah.
Yes, any salary adjustments going forward, we could negotiate, and we did negotiate pay raises. We did repricing in October, and the following April, we settled the contract for pay raises.
And that would be memorialized as some addendum or some.
That's in
Agreement.
that's in the green contract that you see people I'm referencing. That's the
Okay.
current CBA, which is 23 to 27.
Okay. No, I think that's it. Thank you very much.
Thank you, Chair.
Ms. Rushman, I just want to clarify this first, right? This was a situation where the legislature appropriated the funds first.
Yes.
Before there was any type of repricing agreement or anything of that nature, correct?
Yes, with that proviso. Mhm.
Right. And they actually mentioned repricing.
Correct. Very unusual.
And then the governor signed off on that to, I guess, release the money, approve the act.
Correct.
But in this situation that we're here for today, right, the legislature is not the employer.
Correct.
Okay. And so, like you said, this was an unusual situation as, because you'd never experienced repricing before, at least an unusual situation as compared to collective bargaining. Would that
Correct.
be fair?
Correct.
Now, let me ask you, in this situation, the employer is the Department of Education, correct?
So technically it's the state of Hawaii Board of Education.
Okay,
Um,
but it's a
there's some
separate
weird stuff
jurisdiction.
because of charter schools, but yes,
Right.
yes, it's a separate jurisdiction. So for the purpose of this discussion, yes, Department of Education.
Okay. And with your explanation. And let me ask you, based on your experience, and I'm going to include for purposes of Mr. Bacon's testimony, as I recall it, and Mr. Takei's questions, that in the course of the collective bargaining, I'll say meetings and negotiations, discussions that you had, was it ever represented to you by the DOE that they were conducting a review, i.e. repricing of the classes within bargaining unit 5?
In the bargaining process, no.
And I hope you still have it in front of you, 89.9.
Yes.
There was several questions about this. If you read the complete first sentence, not just part
Are
of
we
it.
reading it too? F2?
Yes, F2.
Okay, okay.
Excuse me. The whole sentence. Would you agree with me that, first of all, there's the use of the word shall, which means mandatory, correct?
Yes.
Okay.
Yes.
So the employer of each jurisdiction, which in this case, DOE, Board of Education,
Yes.
right, shall ensure establishment of procedures, and we can stop there at that point. It doesn't say written, but it just says establishment of procedures, right?
Correct.
To periodically review at least once in 5 years, unless otherwise agreed to the parties, the repricing of classes within the bargaining. Now, reading that sentence in total, would you agree or disagree with me that that establishment of procedures is referring to how the repricing review would be conducted?
Yeah, that's my read of the statute.
And in this situation, your first notice of the use by the employer of 89.9 F2, I think you said it was maybe late July, sometime in August of 2022.
Yeah, so just to give some added context, because I think it was referenced in some of the exhibits, we were hearing out the legislature that they were interested in providing money via a repricing vehicle, and you saw in our communication to membership what Sylvia Luke had communicated in her statements. And so we knew that that was something the legislature was willing to appropriate, and they were willing to appropriate repricing money. But the actual employer coming to us and saying, okay, now we're ready, we want to initiate a conversation, was not until after the governor signed the bill.
Okay.
Or
And
signed the appropriate, the bill.
okay. And during that initial conversation, or one of the initial conversations, that's when the employer notified the union that it was going to utilize 89.9 F2.
Yes. That they're gonna do the employer discretion.
Okay.
Very, very clear. It was going to be at employer's discretion.
And I am not going to spend all the time trying to find that exhibit, but there is an exhibit put out by the Office of Talent Management that discusses the credit we went over earlier, where, what is it?
The CU 17, the new salary schedule for entering and re-entering,
CU 17?
which is big number.
317 is a bill.
C
No, no,
C 88,
88?
yeah. Yes, that's the one.
Yeah.
Thanks.
The recruitment document?
Yes,
Yes.
and so under that prior experience credit,
Mhm.
and I understand this is not put out by the union, so with that caveat, right, this is
Uh-huh.
put out by the.
Yeah, this is the
employer.
recruitment
Right,
flyer, if you will.
is there any mention in there that once you receive the salary credit for up to the maximum of 6 years, that it can either be taken away or disregarded in any fashion?
I haven't looked at this in a while in detail, but I don't believe that there's anything in there that says that.
And under the 89.9, sorry,
That's fine.
under the 89.9 F2 language. And let me back up for a second. In just the first sentence of that section F, where it says the repricing of classes within an appropriate bargaining unit. Would you agree with me that in this circumstance, the appropriate bargaining unit is bargaining unit 5?
Correct.
And within 89.9 F2, is there any type of language that you would interpret that allows the employer to exclude or carve out a certain group of the class in the repricing?
I would say that there's nothing that says that there's an exclusion.
Do you know of any other authority within Chapter 89 or Hawaii Administrative Rules, if you're familiar, that would authorize the employer in the course of doing a repricing to carve out or exclude a group of members of the class? That no? Ms. Eshman, oh, sorry, one other group of questions. Is it your testimony that DHERD was, I'm trying to search for the right way, you correct me if I'm wrong, was DHERD the lead party in the discussions regarding repricing on the employer side?
When you say lead party, can you help me understand
Sure.
what you mean by that?
I'll rephrase it this way. Is DHERD part of the Department of Education?
No,
Was it DHERD that was they the group that initiated the repricing and informed HSTA that they were going to do the repricing methodology?
no, it was the Department of Education. And in fact, after we did the DOE repricing, because there was money in a separate proviso for charter schools, we had to actually notify all the charter schools that there was an opportunity, because of course those members were contacting us saying, what about us? And so we actually had to then basically explain to them the process, and then
Right.
those charters did a similar process to the department.
So under 89.9 F2, the established procedures, in your opinion, would be of the Department of Education, correct? Not of DHERD to apply to this repricing situation.
Yeah, it says the jurisdiction. So the jurisdiction would be the Department of Education.
All right. Thank you, Ms. Eshelman. I have nothing further. Board member, sure.
Yeah, well, Ms. Ashman, that's that same provision, 89-9, F2. describes a periodic review at least once in 5 years.
Mhm.
Do you know how that 5 years was calculated or how the 5 years were set with the DOE?
I do not. I know that Mr. Bacon testified that, they did it in conjunction with collective bargaining.
Yeah, but he didn't set a date, let's say like every
No.
5 years, so we started
mean-
here in, 2018 and
Yeah, for our unit, the current contract's a 4-year contract, the immediate prior, this one is a 2-year, and then the 2 prior to that were 4-year contracts.
so the one before, so the one.
So
before
20,
yeah,
so 21-23 is a 2-year,
yeah,
and then it was 2019 to 2020, no, is that right? 2019 to 2021, and then 2017 to 2021, then 2030, no. It's been a long day. I gotta count 4
Yeah.
years. 2013. Yeah, 17, okay. 2013 to 2017, 2017 to 2021, and then this one is 21-23.
okay, and then, oh, yeah, here it is. No, I think you covered this, but I just want to make sure, because I think this squares with your testimony. I think Mr. Alapo was questioning you about the effect upon the 3 complainants. If the DOE had taken away their non-BU 5 experience.
Mhm.
And I think you commented that no one was moved backwards.
Correct.
And that was at the insistence of yourself or the HSTA.
Yeah, in particular, Mr. Reid, because his time in the department is much less than Miss Campbell, Miss Bess, because of his experience credit on initial placement, and then if you apply the facts of the compression movement, it would have been only he would have only been at step 7 after his time and applying the criteria. But he is already at 8, and so they did not move him backwards. So I have a larger chart for every employee, and so on his chart, it says -1 in the sense that he actually would be moved backwards, but we got agreement that no one would move backwards.
I think you testified that you succeeded in this, or the HSTA succeeded in this.
Yeah, we were worried that those folks that were kind of on the top part of that chart
Yeah.
would potentially lose steps. And so we made it very clear that that could not happen.
But they couldn't do that, right? Could the DOE unilaterally
I think we would have had to grieve it if they tried to do that.
would be grievable, right? Right?
Yes, sorry. I forget that to say the yes.
Okay, thank you.
Thank you. Board Member Moipono, you have any other questions based on our questions? Okay, no. Anything else, Mr. Reid, based upon the board's question?
Just a couple regarding their experience interpretation. Actually, never mind. It's already been discussed.
You have no more questions?
No more questions.
Mr. Alapa?
Just for the record, you referenced the Brown Book a couple of times.
Okay.
Were you referring to the CBA between HSTA and the Department of Education or Board of Education from July 1st to 2001 to June 30th, 2023?
2021 to June 30th, 2023, yes.
Yeah, and this is also entered into evidence as Board Exhibit 1. Just for the record, thank you.
Mr. Takei, anything further?
No question.
Thank you. Ms. Eshelman?
Thank you.
You are excused and safe travels.
Thank you.
Mr. Reid, are you gonna have further witnesses in your case against HSTA?
Yes.
And who would that be? We're just dealing with procedure right now.
Yeah. It'll be Ms. Campbell and myself.
You have any estimate, and I won't hold you to it, but some estimate over how long you think that testimony is gonna take?
I'd like to do it continuously, like without the break of the day. I wouldn't be opposed to holding off till tomorrow, if that would please.
Yeah, normally we would end at 4. Yesterday we went to, I think, a little past 4:30. You would not be able to get through the testimony, and that's
Before 4 o'clock.
cross-examination of both of you by 4:30. Your best estimate?
I think so.
You think
We can try.
so? You think so? You
Oh,
could
I-
get done or not?
I think we can. It depends on follow-ups, but yeah.
What is, so, okay, I understand your preference, Mr. Alapa, your preference.
Ms. Campbell has testified already and we've asked questions already. At least they go into a whole new area. I don't anticipate too many questions on my side.
Okay, Mr. Takei?
I concur with what Michelle Lopez said.
Okay, Mr. Reid? Ball's in your court. Who's testifying first? Campbell, are you testifying first? Remind you, you're still under oath. You can proceed, Mr. Reid.
Ms. Campbell, can you tell us what you tell us about how your case almost went to arbitration?
I'm gonna object to this line of questioning, and I think it relates to the additional exhibits that the complainants have attempted to enter into evidence. The issues involved in this case do not allege that the union acted in bad faith, arbitrarily, or with discrimination and decided not to take this case to arbitration. So we're going into an area that's not relevant to the issues in the complaints and the issues that were identified by the complainants in this pre-hearing statement.
What is the relevance, Mr. Reid?
We are alleging that the Hawaii State Teachers Association did operate under bad faith and interfered with interfered with our efforts to bring the case, and we just this is testimony to that.
Well, Mr. Reid, you're here, right?
Yeah. Well, they were not successful.
You've brought the case.
Yeah. Yes.
We've been here for the last 4 days doing the case.
Yes.
So what's the relevance of what happened?
I guess we're not claiming the interference was successful in stopping us from being here. We're claiming the interference happened and should not have been interfered with.
You lost me. That again, what does the arbitration process or whatever that Ms. Campbell participated in, how is that relevant to any issue in this case? Are you trying to tell me that by refusing to take Ms. Campbell's case to arbitration, that it interfered with her rights?
No, what happened was, there was very inconsistent communications from the Hawaii State Teachers Association, and that very inconsistent communication between the department, between HSTA and the department, and HSTA and Ms. Campbell caused issues in the boardroom during her first case before the HLRB. And we are pointing out the fact that the Hawaii State Teachers Association committed the acts which completely ended a hearing.
Ended what hearing?
I'm not sure exactly which hearing or the date or what the topic was, but there was a hearing, and the inconsistent communications became an issue, and the end result was that they had to stop, and they had to go back and solve some issues between the HSTA and the Department of Education, because
Even assuming that I understand that explanation, what section of chapter 89 that you've pled, does that violate?
It probably doesn't. If you're saying I just pled the beginning of 89.3, then yeah, it doesn't. If I understand your definition of what I've pled, then yeah.
No, it's not my definition of what you pled,
Yeah.
it's what you pled.
Yeah,
I mean,
yeah.
the words speak for themselves.
Yes.
So I'm just, and I'm not making a decision yet, I'm precluding you. I'm just trying to find what the connection is between, and what I hear you saying is whatever Ms. Campbell went through in the arbitration process pursuant to the collective bargaining agreement somehow violated something in chapter 89. And so I'm trying to find out, based upon what you've pled, what section of chapter 89 are you claiming that violated?
89.3. Although I'm not sure I fully understand your descriptor of that I pled.
In your complaint, did Ms. Campbell, as far as you know, because you're representing her, in her complaint, was it alleged that somehow chapter 89, a specific section of chapter 89, was violated because apparently the HSTA didn't take her case through arbitration?
It wasn't so much that they didn't take it through arbitration. It was the fact that they obstructed the case. And I
Is that pled anywhere? That you on behalf of Ms. Campbell, it was pled that HSTA obstructed her case or her rights under the collective bargaining agreement? Or I still don't understand.
by pled, just so I understand the terms. These terms are, I don't know all the terms.
Okay, your
By pledge,
allegation.
the allegations. With regards to the latest, with the third amended complaint, or
So the third amended complaint, I'm gonna give you one more chance, Mr. Reid. If you cannot connect the dots on how Ms. Campbell participating in the grievance process or getting up to the arbitration process violates some section of 89 that you've alleged, then I would fail to see the relevancy of this testimony.
well, we have pled that they violated 89.3, and we have pled, well, to the best of my knowledge, we have pled that that the HSA is violated 89.3, and that 89.3 contains our right to concerted activities to fight for our rights, and their behavior was interfered with that. So that's
I'm going to represent to you that there is no right to proceed to arbitration on behalf of the members, and if that's your theory, then, and is that the only thing Ms. Campbell's gonna testify?
No, she has more to testify to.
What, and just under an abundance of caution, what is the offer of proof to the other things she's gonna testify to?
I don't understand the phrase offer of proof.
Just give me a brief description of the other issues she's gonna testify to, not her actual testimony, just the issues.
She is going to testify as to the, she's going to testify as to as to our alleged bad faith actions by the HSTA, and how the communications did not represent trustworthy performance of their duties, and how the facts as we allege them, how the facts as we allege them do not represent a trustworthy performance of duties. And
All right, Mr. Reid, Mr. Lapa, I'm assuming you would object or renew your objection if there's any testimony regarding the arbitration or grievance process.
Yeah, absolutely. And there's no reference to that process in the complaint. I just reviewed it again. In the pre-hearing statement from the complainants or in the issue statements. In fact, it doesn't even cite to the CBA as it applies to the HSTA. Again, the issues against HSTA is a alleged duty to bargain, failing to follow that duty. That's what the claim is, in addition to the discrimination claim.
that,
And we're gonna be here all day if we go beyond the scope of what, and it's a due process issue. We have the right to be given fair notice of what the claims are. We went through it, and it's nothing, this is way outside the scope of what was discussed and provided to us.
it was our understanding, it was my understanding, that any case in a hybrid case involved us having to prove either arbitrary discrimination or bad faith on regards to the HSC, or on regards to the exclusive representative's performance of duties during the process. So I without looking at it, I can't say for certain. I can't say for certain the words bad faith were in that, but it was my understanding that was the whole, that was the point of bringing the union in, is to demonstrate that. Maybe that was an omission from the statement of issues, but it was our intention, and that was given. That was like the whole point of the case against the Hawaii State Teachers Association. So I didn't, had I been aware that the statement of issues was extremely exclusive, I would have done better, but I haven't done this before.
Mr. Reid, in Ms. Campbell's complaint, the only thing that I see is a claim to refuse to bargain collectively in good faith with or a refusal to bargain collectively in good faith with the public employer. And so how does Ms. Campbell's testimony relate to that? And that's a citation to 8913B2.
It's my understanding that those specific charges were not dropped, but they were removed, and then other charges were added on. And in the process of amending the first, second, and third complaints, we were strictly instructed to only add very specific text. And so
okay, you're talking about these complaints. Okay, what you filed was what you filed. And so if you said you got other questions other than the arbitration process, go ahead and ask, but it's going to be subject to, I'm sure, the objections of Mr. Alapa and Mr. Takei. So you can proceed. I'll give you a chance. to see where you're gonna go with this.
May I have a brief minute to confer with Ms. Campbell?
Very brief.
Board member Moniz,
Yes,
could I just have a brief minute with you and Chair Oshiro?
yes.
Okay, can you call me?
We'll stand in recess. We're rolling. Back on the record. Mr. Alapa, I have a question for you. Is it still HSTA's position that, because I believe this was raised in earlier pleadings, is it still HSTA's position that the complainants did not exhaust their administrative remedies?
I believe that's been dismissed by the board. I did raise it in a motion, but it's been dismissed.
At this point, we're gonna recess for the day because we're gonna finish the two witnesses today. But, you know, Mr. Reid, I am gonna say that first thing tomorrow morning, the first order of business is gonna take up Ms. Campbell's proposed testimony. And if it is going to be about the grievance process or arbitration, or what other issues are you going to get into? And the reason why, just so you understand, is because Ms. Campbell has already testified. And I know now this is the case against HSTA. So the issues, as have been alleged in the prohibited practices complaint, is what we're concerned with. Okay, so we'll have this discussion again first thing in the morning tomorrow. Do you expect on calling any other witnesses other than Ms. Campbell and yourself?
No.
And if something arises in the meantime that you have to change, we'll deal with that at that time. I'm not going to hold either one of you to it, but I'm going to ask, do any of you foresee the possibility of calling any rebuttal witnesses? Mr. Alapa?
Yes, I intend to request to call either Riker Wada or Travis Palmera based on the testimony from Ms. Eshelman during our case in chief and the contradictory testimony from Sean Beacon.
Okay, we'll deal with that and when it comes up, Mr. Takei. And again, I'm not holding you folks to this. I just want to get a sense.
I don't foresee any rebuttal witnesses at this time.
Okay, thank you.
Board member, if I could request, just so if the board does allow me to do so, if I could request the employer either contact one of those two witnesses and check on their availability for tomorrow afternoon, just so we can, you know, get this thing done if I'm allowed to call one of them.
Mr. Takei? Because I know Mr. Wada is no longer employed with the state.
I mean, I'll go back to the office. I'm not personally familiar with these people or their contact number or anything. I can go back.
Well, it's my
See if I can find
understanding,
their
you can try, because my understanding is Travis still works with Department of Human Resources Development. Mr. Wada is no longer employed with the state, but I guess if you're willing to do your best effort, that's all Mr. Alapa can ask.
May I be excused from the responsibility for Riker Wada then, or I mean, I can try my best for both. I personally am not
And
familiar.
that's all I'm gonna ask you. That's all the board is
Sure.
asking you for. Just try your best. Mr.
Small-
Lapa, is that okay with you?
Yeah, and then the alternative, if I'm granted the ability to call rebuttal witnesses, one of these two, then if you can't bring them tomorrow voluntarily, then but I have to ask for leave, to subpoena these witnesses, and force them to appear, so. Yeah,
Understood.
and one for after subject, I want to make one clarification to hopefully speed things along tomorrow.
Sure, go ahead.
Okay, thank you. Mr. Reid, made a comment about he should have the right to present testimony about bad faith. And I just want to be clear on what my objection is. If he's presenting evidence about bad faith as it relates to the union's decision not to bargain, I don't have an objection to that. And I think you've already explained what my objection pertains to, so hopefully that clears things up for tomorrow when we continue.
You understand that, Mr. Reid?
Yes,
Because there is allegations regarding the bargaining aspect and that being done in good faith or bad faith. So that's in the prohibited practices complaint.
yes.
All right, then, we will, anything else?
I have one more issue.
Sure.
I would like to ask the board to take judicial notice of Jennifer Kramer's case, to testimony of Sean Bacon, April 25th, 23.
And the basis for that is,
That it is contradictory to what has been said in the past couple of days, and probably contradictory to what we're about to hear whenever he comes back.
I will take that under advisement and let you know tomorrow. And what, just Mr. Bacon's testimony, or you want the whole case filed as judicial notice?
Yeah, just Mr. Bacon's testimony.
Okay, and understand, Mr. Reid, I don't have Mr. Bacon's testimony in front of me, and my understanding is that that case has not been concluded
Yes.
yet. It's
That's
still
correct.
ongoing. But we'll take your request for judicial notice under advisement. I should let Mr. Alapa, you got an objection?
Just for the record, the HSTA was not a part of that proceeding. I've never seen
understand.
the testimony, never read it, so.
Yeah,
I
and
obviously have to look at it first before getting position. Thank you.
absolutely. And I wasn't a member of the board at the time that case was heard. So, Mr. Takei?
I also object that board taking judicial notice of that. Not the same claims, not the same parties. And in addition, the complainant had full opportunity to examine Mr. Bacon and ask anything he wanted. And so to say that he wants to somehow take judicial notice for whatever intent, perhaps for contradictory statements of some sort, Mr. Bacon doesn't have an opportunity to respond or give any rebuttal to whatever intention he wants the transcript statements from the previous case.
I understand your position, Mr. Takei. Mr. Reid, I'm also going, while we're taking it under advisement, subject to the objections of Mr. Alapa and Mr. Takei. Introducing Mr. Bacon's testimony from another case, if you want us to take judicial notice. And I will confer with the board, but I'll tell you my initial implication would be, or indication would be, it would reopen the issue of recalling Mr. Bacon as a rebuttal witness. So I just wanted to let you know that, because if we do take judicial notice of his testimony from another case, then we have to be fair to Mr. Alapa and Mr. Takei. As you know, Mr. Takei already requested to allow Mr. Bacon to come back in and testify, and I denied that. And so if you're gonna ask to have his testimony admitted from another case through judicial notice, that issue may be raised again. So I just wanted to let you know that.
Okay.
Okay? All right, well, we'll stand in adjournment until 9 AM tomorrow morning. Thank you.
Thank you. Can I leave our stuff here?
Yes, thank you.